Termination of the employment contract. Well, this is a very big topic. Esme and I have given 3 seminars already on this topic for different clients. The same seminar, that's for sure, not 3 seminars, although I think we could have managed to get it into 3 seminars. No, it's a very extensive topic, and so we would love you to join if we host another one, if you are interested. But I will discuss a couple of points just so you have an idea of what it entails. So in the Netherlands, if a contract is not ended automatically at a fixed term, it needs to be ended via upfront permission from either the court or the UWV. And the UWV is an employee insurance agency, and they are also involved with unemployment benefits or with sickness, but they also are involved with giving permission to terminate a contract on the basis of business economic reasons. So that is the first 2, business economic reasons, and if an employee has been sick for more than 2 years, you have the option to end the contract. Then you go to the UWV, you file an application, the employee has an option to defend himself, and then after that the UWV will decide if you have permission or not. With this permission, you still have to give notice to terminate the contract. So those notice periods we just discussed in the previous slides, you still need to uphold them. So with the permission, it's not like, I've got the permission, and you don't do anything, then nothing happens. So that permission is your gateway to send a letter and say, I have permission now, and with this permission, I have decided that I am, in fact, terminating your contract. And of course, every employer will do that because they went through that whole process to get it. So that is the first one. The other reasons, C through H, are reasonable grounds for termination through the court of law. So a company would need to go to the court and ask for termination, and the court will end it on a certain date. So you don't need to use the permission of the court to end it. The court will end it by itself. Sometimes upholding the notice period, sometimes they won't. It really depends on the situation. Sometimes the notice period is added to a severance pay. So it really depends on the case how it is ended, but the court ends it. And you need a reasonable ground. Frequent absence due to sickness, and that really is frequent absence. And being away for 2 days, coming for 1 day, being away again. So just someone has been sick for 4 times in a year. I find that a lot. That's not going to get you anywhere. The second ground, underperformance, that was what our seminar was about, is a very important one. If you find that the employee is underperforming, it is essential to keep a record of the underperformance. Really do have performance reviews every half a year, or twice a year even, and on a more regular basis if someone is really underperforming. Performance improvement plan, have something on file, and then go to court. If you don't have a sufficient substantiated file, you will not be able to convince the court that you have done everything possible to keep this employee employed. Well, there are some other ones. Irreparable damage, working relationship sometimes goes together with underperformance. Culpable acts or omissions, if it's not instant dismissal, but it is a very culpable act, you might be able to go via that route. So there are many reasonable grounds. And important at this point in 2019 is that you have to pick one and substantiate that ground fully. If you're not able to substantiate that ground in full, then you have a chance that the court will not agree to termination. So a combination of these grounds is not yet possible, but will be possible from 2020 onwards. So there will be a new ground I, saying combination of the above, I don't know the exact wording, but then you can combine. So that's going to hopefully make it a little bit easier, because it is quite difficult sometimes to really get one ground substantiated. And for all of them except for E, it is important that besides being able to substantiate the ground, is to also check within the company, but also in affiliates in the group, if there is a possibility to redeploy the employee elsewhere. You need to be able to show that you have checked that and there are no suitable positions within the company. There are some termination prohibitions. Sick employees are protected, pregnant employees are protected, employees who are on maternity leave or in the period after that are protected. So make sure to check if you even have a possibility to end their contracts. The ground rule is that it's not possible to unilaterally, as an employer, end it. So that is only possible in the probation period. You can end it unilaterally. But if you are not in that probation period and it's not an instant dismissal, so straight away, then you need permission from a third party, either the court or the UWG, to get permission to end it. The last resort or the last option, and actually the option that is used most often, is in agreement with the employee. So a settlement agreement, mutual agreement. We do a lot of termination cases here as well. Most of them are settled by a settlement agreement. But even then, it is important to know how strong would you be, hypothetically, in court or at the UWV, because that is the way how to negotiate the terms and conditions. If you have a very strong file and you tell the employee, well, with this file, I've done so much. We have been talking about your performance for 8 months. We've had many reviews. I've documented everything. We had you went to that course to educate yourself on that topic, and still there's nothing is happening. Then you have a pretty good file, and you could go to court. Then you can easily say to the employee, I could go to court, but you've been employed here for a long time. It would be best if we can just discuss it and part ways with the settlement. If the employee or the legal counsel advising the employee knows there's a good file, they will probably do that because no employee wants to go to court. If you don't have a good file, the employee could just say, okay, go to court. I'm not settling unless, and then you're talking money. So then you talk about severance payments or a longer notice period or exempting someone from work, because you need the agreement, you need the employee to sign off on a settlement agreement. And they probably won't do that if you've done nothing. I mean, if someone has been employed for 10 years and then a new manager comes in and thinks, nah, it doesn't work, that doesn't work. You really do need a file substantiating as to why an employee can no longer stay with the company or be redeployed somewhere else. So settling is certainly an option mostly used. But when we advise, we always try to first find out how strong is your case, to also come up with a fair first offer and advise the company on how far they should be willing to go to part ways. Something that is going to change in 2020 as well is the transition payment. So when an employee contract is either terminated or not renewed, the employee has a right, is eligible to a transition payment. And the transition payment is meant to give the employee the opportunity to transition to a new company. I don't think anyone uses it for that, but okay. For schooling, for coaching, if there's a gap in between the employments, to have a little buffer. And this transition payments at the moment, now in 2019, an employee is only eligible to this transition payment once the employee has been employed at the company for 2 years, 24 months. As from January 1st, 2020, this will become an immediate option for the employee. So from day one of the employment, the employee will be eligible to it.